Long-Term Planning Committee, Police Oversight Commission order. Welcome, everyone. And first we begin with public comments. Has anybody signed up for public comments?
No.
Okay. Moving on from that. Next we go to the review of the minutes. The first set of minutes are the September 18th minutes. I had some problems with these, but I think we can handle it. I'd like to suggest that we amend these minutes so that under paragraph 2, everyone's got a copy of the minutes. Commissioner Mark, you got it? 2 for 5 lines from the bottom of the paragraph 2, where it says, City Attorney John DuBois informing Chair Shine that, and I'd strike out the rest of that sentence and insert the following language, that the long-term planning committee only had jurisdiction to review matters that had been formally assigned to the long-term planning committee by the POC by formal motion and majority vote of the POC. And that would be that's the change in that sentence. And then in the next sentence, after the words, after further discussion, put a comma and insert the phrase, based upon this legal opinion, comma, Chair Shine moved to remove the 4 items. And the other change I would add is the vote shows Shine, Forster, and Siegel, and Forster is not a member. It should be Shine, Barker, and Siegel. I'd make, and I'd ask the IRO this, when did Commissioner Peterson resign from the long-term planning committee? Was it before this meeting in September?
I don't know. He made the notification to you before you, and never made it to me. So it would be an email to you.
I thought it was December. But
I was notified of it after this meeting, but I don't know if he had resigned prior to this meeting or not.
Well, if we could, in terms of this, since this will have to be retyped with this additional language, if we could check, I'll check my email and call him to see whether he should be listed here as absent or just not listed at all because he's not a member of the committee anymore.
Right.
Would that be all right?
That's fine if you check your email.
I will do that after the
Yeah.
meeting. And if worst come to worst, I think we can call Mr. Commissioner Peterson to see when it was effective. Those are the only amendments I would make to these minutes. Commissioner Siegel.
Thank you. I would ask that the word sub be taken away from the top header, so it just reads long-term planning committee.
Yes, it's not a subcommittee. I agree.
Otherwise, I'm moving
Okay, you move the approval of minutes as amended?
it. I move the minutes as amended.
Second, any discussion? All in favor, signify by saying aye.
Aye.
Okay. Any opposed? All right. And I will give this copy to Ms. Garcia so she can get the exact language of the minutes. The second item is the second set of minutes, and I had problems with these, more substantive problem. On page 2 of the minutes, Roman numeral 5, standards establishing the independent review office, established by the independent review office for inactivating CPCs. I think, first of all, we should reprint the whole rule with all the amendments there. Secondly, I don't believe Commissioner Siegel moved to accept the revisions of number 7. Only number 7 is the.
which minutes are we speaking?
We're speaking of the minutes with December 19th. That's the other set of minutes from the committee. As I recall it, there was some language originally proposed by the IRO for number 7, and we discussed changes in it, and those changes were made. And so all that needs to be, I think, put in here with a vote. There's no vote for final approval to recommend to the POC. So I would, and there was a couple of other changes. It's the same issue whether Peterson was on the committee at that time. And in addition, on Roman numeral 4 on page 2, the last line before the list, should agree to prepare paperwork requesting the following additional staff. That's additional staff, we're not just limited to 2 investigators. And I think the attorney should be struck from that list, because later on, it's recounted that the attorney, we have a separate motion for the assignment of an attorney, or the request for an attorney. And so on page 2, the second full paragraph, where it said, the second line, have a paralegal to review CPCs, and I guess it's supposed to read may rather than might, and may hire a contract attorney to clear up the backlog. With all those changes, I think we're better off remanding these to get the minutes approved. Therefore, I move to remand these minutes for changes.
Chair Shine, I just say one thing. I just now caught this, that the meeting was held on the 7th floor, not in the basement.
The meeting was held.
In December, we were on the 7th floor in that hearing room. And so at the top of the meeting, it says Plaza del Sol hearing room, basement level.
Oh. So this got the wrong place for the meeting?
Yeah.
And also, it shouldn't be subcommittee, it should be committee. And Commissioner Siegel.
Thank you, Mr. Chairman. First of all, I'll second the motion that you just made to remand, but let me add at least my recommended language on item 4. After the second paragraph, speaking of the human resources manager, I would recommend inserting another paragraph that would read as follows, just a sentence. The committee requested recommendations from IRO Hemmer regarding ideal staffing, which she gave. Then it proceeds to say the chair shall move to recommend.
Okay.
But you didn't make that recommendation out of thin air. You made it out of a series of discussions in our consultation with the IRO.
And perhaps after your language, there should be the sentence added, there was a discussion. And then the chair shall move, so that it's clear there was a discussion.
I would ask that you make your annotations and then remand your annotations to the IRO.
Right, we'll give both sets of annotations. Okay, there's a motion to remand the minutes. Any further discussion? All in favor signify by saying aye. Aye. No, any opposed? None opposed, it's unanimous. So perhaps you could, we'll put these in the file here. Okay. The next item on the agenda is APD training and practice regarding the search of homes and businesses to ensure officer safety. If you recall, this matter came up before we had the problem with the long-term planning committee's jurisdictional authority. This matter came up as a result of our reviewing a particular citizen's complaint, which led to the question of whether officers are under the impression that if they enter a house, they have a right under any circumstances to search it for their own personal safety. And we had at one point the director of the training department for the APD come to our meeting here at the long-term planning committee, and basically he said he's not a lawyer and he couldn't really respond to any hypotheticals, but indicated there was a statewide approved training on this issue, and that he would see what he could do to provide us with that training material. And I had asked the IRO to look into it before this meeting. And Ms. Hammer, where does that stand, if you would?
I forwarded the request to the Albuquerque Police Department chain of command, including Mr. Wolf, and I believe that Sergeant Mock is prepared to answer on behalf of the department.
Okay. Sergeant Mark, welcome.
Thank you. Again, I'm not going to be able to speak on total training. I know I've spoken to our deputy chief, who advised that he would be able to get somebody out here to provide what that training was, because I wasn't given any documents as far as any training that is provided to our cadets. Again, he said, you know, given some time, he'd be able to arrange that, but because we are in transition right now, and the short notice, we weren't able to get anybody here from the academy to give that lesson.
Okay, we were interested in two things. One, that person who's actually giving the training to cadets, or if it's in what do you call it, continuing training, or whatever that's called, or the term that's used.
MOE or continuing education.
MOE, yeah. And also getting the written training materials as well, that we could hopefully have distributed to the committee before the committee meeting, so that we could review them and be prepared with questions and any clarifications that needed. So if we could get both of those, could we do that for the next meeting? And
I will try. I don't know that they will give the training materials though, out. I'm not sure about that, so.
Out to, you mean even to the committee?
Yeah, I'm not sure if they'll do that. So
Okay.
that's something that I would have to get approved and see if they'll do.
Okay,
be willing
that's
to do
fine,
that.
that's fine.
But
I
as far
think
as having the trainer coming out here to speak with you all and everything, we can try and arrange
Okay,
that for the next meeting.
and if you could, we would request the training material, and I thought Mr. Wolf said the last time he was here that he could provide the training material, but whatever you have
I
to
don't
do.
know, I'll have to, like I said, get it.
Whatever you have to do, I would appreciate you doing,
Okay.
and see if we can do that.
No problem.
And we'll reschedule it for the March meeting, and hopefully by that time, things will be settled a little more, the APD is even respond. Okay, thank you very much. Yeah, Commissioner Siegel.
It also might interest APD staff to read and review our last year's civil rights training, which was on Fourth Amendment rights of search and seizure. Much of it was from the perspective of the officer's rights and the officer's limitations. So there's a little bit of data that the IRO has, which she distributed to us, a small amount of reading, and it wouldn't take them very long to review it and be able to understand what it is we know and react to it, comment on it, and so forth. It'd be helpful for them probably. Thank you.
Anything further on this matter? Okay, well, moving on then to a review and analysis and recommendations regarding the following SOP, that is security and bathroom breaks. If you recall, there was at one of the citizen complaints we had, the issue came up where I think a 70-year-old man was in handcuffs at, I guess, the prisoner facility, and had to go to the bathroom, and the officers felt they didn't have any discretion to have him, to uncuff him in any way, so that he wasn't able to do personal things with the handcuffs, obviously. And so we referred that for a possibility of amendment for an SOP, and I don't, what's the status of that, Sergeant?
We do have SOP that pertains to that, and it does, state that we can provide, bathroom requests to prisoners. It's also going to be dependent on how disrupted the prisoner is. It does state too that they can either take off their handcuffs if they feel safe enough, or remove the handcuffs and put them to the front. And they're to be escorted to the bathroom and things of that nature. So we do already have policy in place that if it is reasonable, then they're able to do that.
Is that new? Is that policy as a result of this?
The policy took effect the revision was effective 8/21 of 2013, and it replaced 11/05/12. I'm not sure as far as prior to that, but prior to that, just from my experience, we've always taken prisoners to the bathroom if we were able to. If we're in a location where there's a bathroom,
Yeah,
we'll take
it
them to the
wasn't a
bathroom.
question of taking them to the bathroom, it was a question of unhandcuffing, so we could.
And like I said, they will, depending on the demeanor of the prisoner, and if there's any safety concerns, then they have to take those things into consideration.
Cool.
I don't know what his demeanor was or anything like that.
No,
during
I
that.
think there was not an issue of a demeanor at all. at
So
the
they
time.
could, and it's going to be based on their discretion whether or not they'll take them off or not. But they can remove, put them to the front,
Could you get us a copy of that, or maybe through the IRO, give a copy to the IRO so she could distribute it to to us and the full POC?
Sure.
Because that was an issue of concern to it. Do you remember, Ms. Hammer, whether that CPC came before us before that August 13 date or not?
I don't recall, I'm sorry.
Could we check on that? Just so we could see whether this is a response to that issue from the CPC or not?
I don't know, well, I can try.
Okay.
We don't really categorize CPCs by
Yeah,
type.
I think it might be not a complicated issue to go through and, well,
We'll
I
figure it out.
appreciate whatever you can do. Anything further on this item on the agenda?
Yes.
Commissioner Seaver.
Only that my memory of that case when it came before us was that it was not at the PTU or prisoner transfer unit. It was at a substation that the problem occurred. And I don't know whether that impacts the way SOPs are worked with and followed. But I think at the time we were given to understand there was no controlling SOP. That troubled us. It's possible that there was one, it was overlooked, and I don't know exactly. So it is useful to find the case and try to get to the bottom of it.
Yeah.
It was important to us to see citizens' dignities preserved to the greatest extent possible. Of course, officer safety is important as well. Nobody questions that, but we're trying to ferret that out and understand.
I would follow that up with, I assume this SOP you referred to, Sergeant, applies when anybody's in custody of a police officer, whether it's at the transport station, substation, or whatever.
That is correct.
Right. And my recollection was we were told at the time, that's why I'm a little confused, and I like to check the dates, we were told at the time that the officer had no discretion. That once he put the cuffs on him, he had no discretion to take the cuffs off to permit the person to go to the bathroom. Even because this was a 70-year-old guy who was arrested for some minor thing, and it was, from everything we heard about the case, there was no suggestion that he was any kind of a security risk.
We can pull the case, but my recollection, he was arrested for domestic violence.
You may be right, I have no
So
recollection.
there were some concerns.
Okay. But I mean, there was no indication at the time this happened that
At
he
the
was being
moment.
disorderly or a problem in any way. So that's why we're following it up on it. And I appreciate any help you can give us, Mr. Sergeant.
Yes.
Thank you. Anything further on that? Okay, the next item on the agenda is the review and analysis and recommendation regarding the following SOP.
You missed 7.
Pardon me? I'm on 6. Relating to an officer being permitted to make false statements as part of a lawful criminal investigation. And this came up for the benefit of the sergeant, who may or may not have been there at the time of that hearing. This came up because of a CPC that we were reviewing, in which the officer, I guess using what's called the re-interrogation techniques, which are pretty controversial themselves, but anyway, they're adopted by most police departments around the country, falsely stated what he thought the state of the evidence was, and when he was investigating a sexual harassment allegation. And I had no trouble with that. I mean, I understand that that's in the courts have upheld that kind of misleading statement by an investigator as part of an investigation when he's interrogating the suspect. My concern was the misstatements that were made to third parties, to potential witnesses that were also false. And I certainly am not that familiar with the re-interrogation technique, but I was concerned about, and the POC was concerned about, the extent to which an officer can misrepresent the facts in some way in dealing with third parties, particularly when the allegations that are involved are allegations which are defamatory, if untrue. In this case, sexual harassment. You can hypothesize all kinds of things, rape and all kinds of terrible crimes that an officer could claim he had evidence of in talking to a third party, when in fact the officer does not have evidence of that, and in the process of doing something in under other circumstances would be the basis for a defamation suit. And so we wanted to, at the time we were told, as I recall it, that there was no specific SOP dealing with this matter, and that's why we wanted to look into it. And any help you could give us, Sergeant, would be appreciated.
Again, it's an interview and interrogation technique. It's not just an interrogation technique that officers do use. And that's going to be situational as far as who they're going to use that type of technique with. It's my understanding that in that CPC, that a person was a girlfriend of the subject, so it would be most likely that she would probably, switch. So I would say that she would probably most likely be more of a hostile type witness. So, he probably chose to use that technique with her. Again, it's just a technique. It's a tool that officers use, and it's been accepted. There's case law to show that it's been accepted. And
Has there been case law about interrogating third parties? What do you know?
there is, not that I'm aware of, as far as third parties.
Is there anything in the SOPs that deal with interrogation technique?
Not with technique, no.
And there's nothing that deals with this issue
No.
specifically?
No.
Well, your colleague, is this can you tell me who's sitting next to you?
Yes, this is Sergeant Scott Norris.
Okay.
He's also in Internal Affairs.
Okay, so he's one of your colleagues in Internal Affairs?
Yes.
Welcome, Sergeant.
Thank you.
Well, one of the possibilities is that even though the Reed, let's assume that the Reed techniques or training authorized false statements to third parties as well as, or trained to use false statements to third parties as well as suspects. Theoretically, we could be recommending to the department that they not permit officers to do that when they're dealing with third parties, particularly where it could be defamatory, and the allegation is not corroborated in any way. There's all kinds of limitations you could put on it. Because the thing that was striking about this case was you had a very angry woman who had just been fired. The case that precipitated this, a very angry woman who had just been fired said she had texts and tapes and texts and email messages on her cell phone showing harassment, but her phone wasn't working, so she couldn't give it to the officer. So the officer was making allegations based solely on her uncorroborated allegation, and that was of concern. The IRO, please.
I would say that there was cooperation from a second witness who observed some behavior by the suspect, so it wasn't totally uncooperated. And in that, I think that it's a very fact-specific case that we're talking about. If you want to talk about the practice in general, I think you should, but I don't think you should tie it back to the case that was before the POC, because I think the facts that were before the POC fully support what the officer did. And in fact, the officer made very little statements to the girlfriend of the object, the target, if you will. And later in that same interview tells her, well, the officer admitted to the girlfriend he did not in fact have that evidence. So I think that if you want to talk about the matter in general, I think it's great, but I think that extrapolating from that individual case isn't necessarily warranted, because there are lots of factors under whatever rule you set up which would in my mind permit what the officer did in that case.
Okay, I take your point, and I don't disagree with it. I just focused on the case to explain why we were focusing on it here, not necessarily that that was going to establish any rule or should establish any rule. Well, first, did any of my colleagues have any thoughts on this whole matter that they want to share? Commissioner Siegel?
A little more broadly, I guess I'd like to say that it's my perception that amongst other duties that we have here, we are wanting to advise and work with APD so that if you're doing a practice that could get the department sued or in trouble, it's worthy for us to bring it to your attention. You should speak to your own legal counsel about it, and be sure if it's a problem that it doesn't happen in the future, or that it's reshaped and proscribed. And then also, as Commissioner Schein points out, even if it's fully legal, it would be reasonable for us to take a look at it with you and not be seen as fighting you, but joining with you so that you're putting your best foot forward to the community and that we're jointly doing something that's appropriate for this community. And in that vein, there's really no question that's inappropriate here. And nor is there necessarily a response that's dreadfully inappropriate. It's a way for us to work together in a committee format. And after that, you can develop policies as you see fit and bring them to the full POC, and we can develop recommendations and bring them to the full POC. Right now, we have, as a committee, zero authority to do anything more than take a little more time to untie the bundle and look at it together. And I would tell you that, from my perspective, we're doing that on your behalf and on behalf of the citizens of this city. And it shouldn't be seen as us chasing you down. I just want to try and recast it that way for you.
Well, let me say, I hope that nothing I said was suggesting that I was trying to chase anybody down. We were just trying to explore a potential policy issue. Commissioner Bach, do you have any comment? Well, I mean, it seems to me that it's appropriate to try to draw a line between some circumstances where an officer should not be permitted to lie to a third party. Assuming for the sake of this discussion that you're correct, that it's generally accepted and the courts have approved misrepresentations to a third party. Because at some point, if the officer has, say for example, the officer has zero evidence that, you know, I'm a rapist, and he goes and tells my wife or someone else that he's got evidence that I'm a rapist, I mean, that seems to me to be a basis for a defamation suit. And it would seem to me that would be the case, and I'd be perfectly interested in litigating it if I was the victim of a lawyer. But you know, so maybe it is worthwhile trying to craft an SOP that will try to distinguish between, you know, those situations where an officer is permitted to make misrepresentations. You know, obviously, if you're interrogating and I know that the Supreme Court of the United States upheld this, interrogating a suspect, you misrepresent, you know, you fail the polygraph or whatever you're misrepresenting in an effort to see if the person will make a statement. And I'm not concerned about that so much. I'm concerned about statements to third parties and what minimum level of information an officer should have before he's authorized to misrepresent the evidence to a third party about some other person. And would that be something that you could bring to your committee, or how might we practically proceed with that? Should we be drafting something, or can you take a shot at it and look at it, or what?
I can present it to the chief and let him know what you would like to be added to our policy. They can take a look at it and see if that's something that they would be willing to work on.
And I think the policy would make it clear if you're talking about, you know, an SOP called misrepresentations of evidence or something like that. The policy would make it clear that if an officer is not conducting a legitimate investigation, he has no authority to make false statements about evidence to anybody, right? I mean, it has to be part of a legitimate investigation. He can't just be in a bar on his own, just having a drink and start making false statements about something. And go from there to trying to define what the threshold should be in terms of making false statements to third parties. But if you could raise that with the chief and give us some preliminary feedback at the next meeting, I would certainly appreciate it. Anything further? All right, let's move on to the next item, the use of force form procedures. This is our interest in this is precipitated by, you know, obviously the whole issue of use of force. And is this another one where you need more time to respond, or?
No, I would be able to tell you what the process is.
Okay, why don't we begin with that?
So the process, once you have a use of force, It's up to the supervisor to ensure that all officers that were present and involved in the use of force follow or do a report. Once that information is gathered, it's up to that.
If we could stop right there and I could ask questions and go along.
Mhm.
When you say all officers, are you talking about only the officers who used force or also witness officers?
Also witness officers.
So both witness officers and the officer using force have to fill out a separate form.
Yes.
And when you say use of force,
Well, it's not going to be the use of force form itself. They're going to be filling out their actual incident report. The
okay,
use of force form is filled out by the supervisor.
okay, I see, all right. So they each file a separate report?
Yeah, well, a supplemental report to the original report.
Okay, that's each officer who was a witness or who used force files a supplemental report about what happened.
Yes.
And in terms of use of force, what uses of force are we including? Are we including fists and chokeholds or
It's
what?
any use of force that results in injury, and it's going to be mace, baton, we have canine, baton,
Are they laid out?
open-handed techniques.
Are they laid out in the SOP?
Yes,
Yeah. What are open-handed techniques?
it would be like a distraction technique with a palm of your hand, or
You know, like slapping someone or?
not slapping, but.
Open-handed techniques. Open-handed techniques refer
Please,
to
Mike, for recording.
Open-handed techniques refer to things such as leverage takedowns, things referred to as arm bars, joint lock controls, impact takedowns, which is also known as an open field tackle. Anytime that you have to use force on somebody to put them in handcuffs because they are resistant to your attempts to put them in handcuffs is considered a use of force.
Okay, so even if you do one of those open-handed techniques,
Yes.
but there's no injury, you'd still have to report it.
Under the current SOP as it stands right now, it's been, I believe, came into effect January 13th of this year.
Of 2014?
2014, just recently. There's been a change in SOP because the past SOP was somewhat vague. I was actually dealing with a complaint myself to where that SOP was left open to interpretation, which was leaving a lot of confusion between supervisors, officers, things of that nature. So I believe that they specified more in the SOP as to, okay, you will fill out what we refer to as a bubble sheet. It's a use of force report form. Whenever an arrest is, you have to effect an arrest by using force,
Even though there's no injury?
even though there is no injury.
Okay, like for example, when I was on a ride along at one point, when one of the bars, a typical situation where the bars closed at Central, there was a fellow who was pretty rowdy and had 6 officers holding him down and having to cuff his ankles and as well as his hands and physically lift him into the wagon because he was struggling so much. So that would be.
That's not really considered a use of force, no. And see, that's where it gets really, that's where we've been having some problems trying to determine, okay, well, what's considered a use of force and when do we need to do a bubble sheet and when do we not need to do a bubble sheet? Because, escorting somebody to their feet when they're resistant in doing so, that's not really considered a use of force. And if that was the case, the bubble sheets that would be filled out would be astronomical in number because of how often that happens. For instance, I kind of recommended that you take a ride along downtown just to kind of see how that kind of goes down at bar closing. So it is situational.
In this case, they didn't bring him to get him to his feet. They literally picked him up by the ankles and the cuffs on the ankles and the back of the hand to carry him to the wagon, and he was that resistant.
Okay.
But that would still not fall into the use of force situation for a requirement.
That would not fall under our use of force policy, no, sir.
And if an officer pulls his weapon and points it at a person, and doesn't shoot him, obviously,
Right.
is that considered use of force?
No, that's considered a show of force. Now, if an officer draws his weapon and points it at somebody, we do write a police report on that. If an officer presents his weapon in a low-ready fashion, that means that the weapon is pointed down to the ground and he's not pointing it at anybody, then a report does not need to be written. Those are shows of force. There's a difference between a show of force and a use of force.
And if he's pointing it at the person,
If he's pointing it at the person, it's a show of force.
and it's still only a show of force.
It's still only a show of force. However, a police report needs to be written on that. If he is pointing it, if he's got his front sight on somebody, so to speak, a police report does need to be written, but it's not a use of force.
What SOP, is it a different SOP than the use of force SOP that requires the report to be written?
I believe that it does fall under our it's referred to as 2-52 use of force. I believe that it does fall under there. However, I do know that we do have a concrete SOP in place that addresses that very issue.
Separate from the use of force SOP?
It falls within our use of force curriculum because it's a show of force. So anything where you're showing force or using force, it's going to fall under our SOP, our use of force SOP.
Do you have any way of capturing how many situations there are in
No.
a year in which there was a show of force?
No, absolutely not.
Are we talking about thousands of such reports?
Thousands and thousands and thousands.
Really?
Yeah, and I can't. I mean, I don't want to guess. I'm going off based on my training and experience and me,
Yeah.
where I worked and how many shows of force that I guess I needed to display. There's no way of documenting that or finding the numbers.
When I say show of force, I'm not talking about the low ready stuff. I'm talking about when the weapon is actually pointed at someone.
No.
And you don't distinguish in those bubbles between the low ready and the...
No, because the low ready or the pointing the weapon at somebody, we don't fill out a bubble sheet because it's not a use of force, it's a show of force.
Maybe I'm confused. The bubble sheet is what?
I'm sorry, that's a use of force report form. That's just lingo that we use out for it. Yeah, I apologize.
But there is a separate report for the show of force.
For when you're pointing a weapon at somebody, yeah, it would be documented as an informational report.
Is it a supplemental report?
No, it would be original report,
Original.
an original offense incident
And
report.
if the weapon is pointed down and just low ready, is there a report for that too?
No.
It's only when you point it at something.
Yes, sir.
Uh,
It's almost the same as if we handcuff somebody. We're required to write a report every time we place handcuffs on somebody, regardless of the situation.
Okay. All right, I interrupted you. So let's go back to the actual use of force. Whatever, open hands or whatever the technique.
So once the officer does apply force, he notifies his supervisor. The supervisor goes out to the scene, gets some information. Then once all that information is gathered, that supervisor will go over all the lapel videos
Okay,
and reports.
if I can interrupt again, when you say go out to the scene, I assume he doesn't get the reports until the next day or something, right?
That's why the officer advises over the air that he's been involved in a use of force. So the supervisor will go.
Oh, he does?
Yes.
So even before any written report, any bubble is made or any written report is made by the officers, the officer's reporting the use of force on the radio so the sergeant can come out.
Yes.
And he will come to the scene contemporaneously with the contemporaneously. Okay, and then he investigates the scene?
Yes. And then once that's done, he'll gather all the reports, like I said, look at all the lapel video or any audio that they have, and then he fills out that use of force form,
Which is the bubble.
which is the bubble sheet.
Bubble sheet, yes, sir.
Okay. And if he concludes that there was an unreasonable use of force, what happens?
Then it goes to, it'll go, well, again, he'll fill it out, it goes up
He
through
or
the
she.
chain, yeah, he or she will fill it out. It'll go up the chain of command, and he'll fill it out whether it's reasonable or unreasonable. Those are the two.
There's on the report form, he's got a choice of saying, making a recommendation as to whether it's reasonable or unreasonable?
Yes.
And it goes up the chain of
Then it
command?
goes up the chain of command. If it's deemed to be unreasonable, then it will be sent to internal affairs for investigation. At times, depending on the seriousness, sometimes the chain of command themselves will handle the investigation.
Who makes the determination as to whether it's warrants an internal affairs investigation?
It's
The first line supervisor or is it
It's
the
usually the
deputy
commander.
chief?
The commander will
The
decide.
commander of the area command?
Yes.
So it goes from...
But then, like I said, sometimes it will go through the area command, and then once it goes to operations review, sometimes they will send it directly to internal affairs.
Oh, you lost me. It's going up from a sergeant
goes-
to his lieutenant.
To the
To the
lieutenant, to the
commander.
commander.
And the commander
The
can choose
commander-
to send it directly to internal affairs?
Yeah, well, it still has to go up through ops review.
What's ops review?
That's, where they track a lot of the use of force. And it's just operations review. I mean, they do everything that comes with operations. So it goes to them, they review it as well with all the tapes, audio, the reports. And if they find anything that maybe the commander missed or anybody from that chain of command missed, then often they'll either send it back to the chain of command for investigation, or they'll send it to internal affairs.
Okay, yes, Commissioner Siegel.
So fairly early on, the sergeant makes a recommendation as to the use of force being appropriate or inappropriate.
Yes.
And is there room in the system for the sergeant to reassess that, make a change to, I would imagine if a sergeant says this was fine, he or she would have a hard time reversing his or her decision. And I'm trying to understand if new evidence is produced, if something comes to light, if they go home that night and think about it and say, I don't know if I should have written it that way. How does that play out in terms of sort of, is this moving through command? Are people just staying fixed in that point of view, or are they?
Well, again, it's not just up to that initial supervisor. It goes through several supervisors. And those checks and balances are in place for those reasons. That if he missed something, if they don't agree with him, he may be a little bit more, you know, maybe he agrees with it and somebody else saw something else and they don't agree with it. So that's where it will get changed.
And then is he or she allowed to make a change too?
No.
Without repercussions, or how does that work?
They don't make a change at all. Whatever they
The sergeant, I'm talking about, for
initiated,
example.
yeah.
First
And that's how it's going to be. And then as it goes up the chain, they'll write their recommendations, and if they feel that there needs to be an investigation, then they will send it back down.
And then that sergeant, and conceivably the sergeant was involved in the use of force, and then in that case it would be a lieutenant, is the first supervisor. They're sort of stuck with that first opinion, and that's adhered to them as a
It's only a
decision.
recommendation, as I understand.
Yes, it's just a recommendation, so.
All right, I'm just trying to understand the process at this time. Thank you.
Let's assume that the sergeant thinks that it was a reasonable use of force. The processing doesn't stop there, does it? It still has to go up the chain.
Yes, that's correct.
And so other people can look at it and make a separate determination as to whether they think it was a reasonable use of force or not.
Yes.
And when you say it goes to operations, does it also go up to a deputy chief and the chief?
Yes, the deputy chief also reviews.
So it's simultaneously with going to operations, it's also going from the commander to the deputy chief?
Yes.
And if the commander, if the sergeant, the lieutenant, and the commander have all recommended there should be an investigation, I assume the chief still has the authority to say, no, there's no investigation warranted.
Yeah, but that's not going to happen. I mean,
That doesn't happen as a practical
yeah, I've
matter.
never seen that happen.
Okay. And when it's determined that an investigation is required, does it always go to IA?
Like I said, not always. Sometimes the chain of command will do it. Usually,
Meaning the chain of command, meaning who, the guy's sergeant?
the
Or
command.
man or woman sergeant?
It's not usually the sergeant. It will usually be either the lieutenant that does an investigation or the commander himself.
The lieutenant in his chain of command?
Yes.
And who makes the determination as to whether it goes to IA or the back to the chain of command for the investigation?
It's usually operations review, the lieutenant that's there.
It's a lieutenant in operations review
There's
who
a
makes that
lieutenant
decision?
there, and then, like I said, the lieutenant and then our field services deputy chief also reviews it. And he's in charge of operations review as well.
So if an investigation's warranted, where it's going to be investigated is not recommended by either this initial sergeant or a lieutenant in the chain of command. It's only initially made by the lieutenant in operations.
Most of the time, yes.
And then he makes a recommendation to the deputy chief for operations,
Yes,
who's the part of the chain of command.
yes.
And the final determination, I presume, is made by the deputy chief as to whether to send it back to the chain of command or to send it to IA for investigation.
Yes.
Do you know if there are any criteria in the SOPs as for which investigation should go to the chain of command and which to IA?
There's no criteria, but they basically like to send the more serious type of use of forces to internal affairs. The more, the less involved ones, they'll do themselves.
Could you give me some examples of each category?
Uh,
When you say
Like I
the
said-
less serious, what kind of less serious things would go back to the chain of command?
Just something like just a regular, where they may be using some foul language, or, it was basic, it was
No,
a
wait,
simple.
use of force.
Yes.
Foul
So,
language.
yeah, so they're using the foul language with the use of force, and if it was questionable, it was something simple where they just did an armbar takedown, and maybe the arrest wasn't a legitimate arrest, and like I said, it just comes into, I can't speculate, it's gonna be, like I said, situational, I don't, again.
If I can say something, that
Please.
that also
Any help
kind
would be
of,
appreciated.
no, that also kind of is dependent as well on how many uses of force this officer has. If it's a reoccurring issue with this officer, I have a case right now to where we have a reoccurring issue with an officer. It's not a use of force. However, the use of force has been called into question, so it was forwarded to internal affairs for an investigation. Okay, so not only am I investigating this officer's conduct, but I'm also investigating whether or not the use of force was good, whether or not this officer precipitated this use of force. So if you're seeing a pattern of behavior, like our early intervention system, things of that, we get those cases, we tend to get those cases, okay? It's also going to be left up to, at times, the discretion of the, for lack of a better term, offending officer's lieutenant. So that officer's lieutenant can initiate and conduct that investigation if he or she chooses to do so.
I mean, before it goes up the chain of command?
Yes, okay? He'll always confer with his or her commander, okay? But they have the discretion as to whether or not they want to conduct that investigation at what we refer to as the area command level, as opposed to farm it out to internal affairs. Now, I cannot tell you what the criteria is on that because it's a matter of discretion.
Yeah. I'm a little confused. The lieutenant can choose to do the investigation. This is after the sergeant's gone to the scene.
Yes.
And this is when the matter first comes up the chain to the lieutenant. Before it goes on to the commander, he can stop at that point and do it in a local, his
own investigation.
His own investigation.
Yes, he gets the report, he reviews the report, he reviews the lapel cams, okay? He makes a decision as to whether or not, okay, this was a justified use of force, it was a reasonable use of force, or this use of force was unreasonable. Now, I have a decision, I'm speaking as if I'm a lieutenant, I have a decision. Do I want to do the investigation, or do I want IA to do the investigation? It could be very well determined on how much that lieutenant has on his plate that week in terms of workload.
When you say the investigation, you're talking about going out and interviewing witnesses and doing the whole 9 yards?
No, well, it's situational dependent. I mean, that could be part of it, but that's not every use of force. That wouldn't happen in every use of force that we do use.
So the effect is, if I understand what you're saying correctly, the effect is that the lieutenant, the supervisory lieutenant, has the power to short-stop an IA investigation.
Yes.
By deciding to conduct an investigation himself, in which case there will be no IA investigation.
You're absolutely right. You're right on it.
Sorry. You want to consult?
It'll still be what's referred to as an internal investigation, okay, but internal affairs won't be conducting that investigation.
I understand.
Yeah.
I understand. And there are no criteria in the SOPs or anything as to when or if a commanding lieutenant should make that decision to do the investigation in lieu of IA.
If it falls under our early intervention system in terms of 5 or more, actually now it's 3 or 4 more uses of force, more than likely, yes, internal affairs will be doing the investigation.
So the lieutenant will choose not to get in the middle of it if it's a repeat offender under the early warning system. He'll just let it pass on to go to internal affairs. Is that what you're saying?
That's correct.
Okay, well, there's some interesting issues raised by this. Let me ask this. How long are sergeants assigned to internal affairs?
Usually 2 years.
And the lieutenants? There's a, there's a lieutenant and sergeants, and that's what constitutes internal affairs?
Yes, we also have a commander now.
Yeah.
That position obviously is still open. But it's generally 2 years per our contract. We can get it approved to stay longer, but it's generally a 2-year term.
What do you mean per your contract?
It's in our union, our APOA contract.
Oh, the CBE, collective bargaining?
Yes.
Agreement, CBA.
Yeah, that internal affairs sergeants can only stay in the unit for 2 years.
And but they can extend.
But they can request an extension.
And there
And that
are
would have to
currently
be approved.
3 sergeants? How many sergeants?
There are 3 sergeants right now and 1 detective.
That's what, is that the maximum slotted position?
No, we are down 1 sergeant right now.
So you have 4 sergeants and a detective authorized,
Yes,
plus a lieutenant to command the unit.
yes.
Okay. Well, let me throw out for your observations. Based on my experience many years ago, and with the Metropolitan Police Department of Washington, in which we were doing some internal investigation, as I was a prosecutor at the time in the U.S. Attorney's Office in D.C., and we were doing an investigation, or the Internal Affairs was doing an investigation into some police corruption that was going on at the time. One of the concerns was that, you know, that there is a lot of pressure on the Internal Affairs sergeants, because they're going back out in the field with all the people who they're also responsible for investigating. And that puts them sometimes in a very difficult position, particularly if they're going out in the field. As part of their work, they're going to investigate some officers, not officers, but like lieutenants and other senior people who might subsequently be in a position to impact on their recommendation for promotion and all this other stuff. Have you? And I think some police departments have changed the way they deal with IA. Maybe I'm wrong in terms of making longer term assignments that IA, or sometimes somehow trying to deal with this problem. Do either one of you have any thoughts in that area?
Like I said, we've had that in our contract for, gosh, it's been 10 years, I think, already. You know, I've not ever had an issue with any field officers or conducting my investigations. I don't have a problem doing any investigations on other officers. Again, if it's a higher ranking officer, generally the lieutenant or the commander is going to do that interview with that.
So you will be responsible for investigating a lieutenant or a commander?
Yeah,
Generally.
Generally, yes.
And that's consistent with your experience as well?
With my experience, I haven't had the opportunity to do any investigations on anybody that is a higher rank than I am. I know that one thing that we've done in the past is I, as a sergeant, may be in charge of the investigation, but during the interviews of anybody who have a higher rank than me, I will have, you know, the lieutenant or a commander in the interview as well. That's my experience up at this point. To answer your question in terms of does it put us in an awkward position to go back out to the field and work with officers whom we've investigated or lieutenants whom we've investigated, I mean, yes, it could put you in an awkward position, but it's also kind of up to you. You know, our goal in internal affairs is not to discipline people, is to find out what happened, if ESOP violations were committed, and if they were, they were. That officer has a problem with it, or the lieutenant has a problem with it, well, then that's his or her problem. These were the SOPs that were violated.
Well, the incident, one of the incidents I'm referring to was an incident this was in the Metropolitan Police Department of Washington, where a vice unit, 3rd District Vice Unit in D.C. was making false arrests of women on the street. You know, in a section of town where there's a lot of prostitution, they're making false arrests of women on the street and, you know, completely fabricating the solicitation language and all that, and bringing it to the prosecutor, to our office and prosecute it. And when I first brought it one night, when it came to my attention, I brought it to a lieutenant who was in Internal Affairs. His reaction was, this has been going on too long, it's time to stop it. And he went out and aggressively investigated, and by the next morning, the 3 officers had confessed, made administrative confessions to the fact that they were false arresting, with the approval of the lieutenant, who was head of the unit. And but the clear message that was given to me was, by that and other things, was that that there's some situations where internal affairs may know there's a problem going on, but they don't want to make waves, and they're not going to make a big issue of it because of the,
Again, that doesn't apply here at APD. If there is an issue, no, I mean, we're going to handle it for the most part. So,
I can't imagine.
again, I have not seen that in my experience. So,
Well, I can't imagine. I appreciate your observations, and I can't imagine you could say anything else but that publicly. I mean, but it is I think it's a potential issue. I don't know how other police departments handle internal affairs. Do you? Does anybody know?
a lot of them are very similar, you know, I mean,
Just 2 years.
some of, not the 2-year restriction, but again, you know, just the way they conduct their investigations and things of that nature, they're very similar.
Okay, so basically what we've got, as I understand it, is the decision as to whether there should be an investigation can be made by the commander's, the officer's lieutenant, or if he doesn't do it, then by the operations and the field commander, the deputy chief of operations, and then they make the decision whether it goes to IA or back to the. Okay, that's helpful in terms of my understanding what's going on. Any other questions or discussion?
No,
Okay. Then let's move back on to the, and I think from my point of view, I'd like to think about what we just learned today and see what we do, if anything, with this whole issue in the future. The last item on the agenda is studies of trends and analysis of all civil litigation against APD officers in the last 5 years. Ms. Hammer, you had indicated you sent an email to Mr. Turek about that.
Yes.
And could you tell me what the email, what did you explain to him in the email, if you could?
It was a day and a half ago. You emailed me, or you and I had spoken on the phone, and you said that you had requested Mr. Turek, or requested from City Legal to come to this meeting to address this agenda item. I forwarded that request, that you were requesting someone from City Legal to come to address this agenda item. And Mr. Turek responded saying that anything that he could provide would be a matter of public record, and he had no staff to collect data. So anything that would be available by public record. And that he was going to send no staff to this meeting because he had no staff.
He was what?
He was not sending anyone to this meeting.
Okay. So you sent him this particular language as to the study that was called for by this language, and he was saying that he wasn't going to do that, or he didn't have staff to do it.
He had no staff to collect that data for you, and that he could not provide you anything that would not be available except for what was in the public record.
Okay, well, and just for your information, and I think what I'm thinking about doing is writing an email to Mr. Turek to better explain, or at least what I had in mind. And that is, as part of this, I was interested in exploring with someone from the city attorney's office what mechanisms were in place, aside from this 5-year study, what mechanisms were in place to deal with lessons learned from the civil litigation. I know that, for example, the more recent, relatively recently, as a result of some civil litigation, there was a new SOP adopted about how long you can detain a witness at a scene in the back of the scout car, you know, without food or water or whatever. But one of my concerns, short of doing the full 5-year study, was what mechanisms are in place to provide feedback between the city attorney's office and the police department to address whatever issues need to be addressed as identified through the litigation. And that's the kind of thing I could, you know, and to ask city attorney's office people. unless you know about it, or either any of the three of you know about it.
In my experience, a lot of times our risk management, who are involved with the city attorneys, will bring up certain issues to our attention, especially if it's something that's repetitive, and then we'll look into addressing those with a SOP change.
So risk management is a city agency, right? It's not a police department agency. Is that right?
That's correct, but they all work together with our legal department if there's certain tort claims, against the department in regards to certain instances.
And also, there's the Claims Review Board, which reviews all claims, reviews large claims against the city, and it's by regulation, a certain level of claim against the department, against APD must be brought before the Claims Review Board. At that Claims Review Board is the CAO, voting members are the CAO, the Chief of Police, the head of HR, and the city attorneys. Those are all voting members of the Claims Review Board. Non-voting members who are present are myself, a representative from City Council, and the risk manager. And so claims against APD are brought to the attention of the chief and myself through the Claims Review Board as well. And the chief hears those claims and can propose SOPs, and myself in discussions with the chief, we discuss responses from the department based on those claims. And my presence at the Claims Review Board is pursuant to the ordinance.
We have, what, 4 voting members of the Claims Review Board?
I believe there's 5, the CAO, the HR, the chief, the city attorney. I think maybe there's 4. I'm not sure the exact composition, but that would be found in city regs.
So what we're talking about is basically 2 informal channels. One informal channel is through the claims review process, which only gets which only sees the more expensive one. Was it $25,000 or more?
Against APD, yes.
Huh?
Against APD.
Yeah, against APD. Whereas the claims review board is looking at claims other than at APD, right? It's all claims against city agencies.
Not all. The risk manager has authority up to $50,000 on non-APD claims, and so claims under $50,000 are not reviewed by the Claims Review Board.
Okay, and for APD, what is his authority?
His authority is $50,000, but claims above